This is Dick Lyford. The following is the oral history of retired Justice Bruce B. Zager. Justice Zager grew up in Waterloo, Iowa, where he graduated from high school. After college, graduate school, a job in industrial relations, and law school, he returned to Waterloo to practice law. He was appointed to the district court bench in 1999 and served there until his appointment to the Iowa Supreme Court in 2011, where he served until his retirement in 2018. Join us now for his oral history.
All right, Bruce, instead of asking the normal questions, when you were born and that kind of stuff, why don't you tell me about your family presently?
Right. At the present time, my wife and I have been married for 47 years, and we have 3 adult children, of course, and our oldest daughter, Mika, and her husband, Grant, have 2 daughters, so we have 2 granddaughters, Kira and Lily, out in Salt Lake City, Utah area. And then also we have our daughter Tara, who's an attorney here, and her husband Nick, and then they have 2 children, Ethan and Emma. So we have the 4 grandchildren, and then we have our son, middle son, Zach, who's out in Denver, Colorado. And I think he's somewhat of our adventuresome one, so he's flying to Germany today to go visit some people. So that's our family right now, and my mother is still alive up in Waterloo, and so we go visit her quite often, and but my dad's gone.
And you said you've been married how many years?
47 years, it'll be 48 in August.
So you must have met in high school.
Yes, we actually met in junior high school, and probably the 7th grade, and you know how that goes sometimes in high school, in junior high school, where you're on and off, but ultimately we're on, and got married right out of high school, and have been married ever since.
Okay. And you grew up in Waterloo?
And born and raised in Waterloo, Iowa.
All right, and how old are you?
I'm now 66.
Okay, all right. So what did you do in high school? You're an athlete, you were studious?
I would not say that I was a studious individual. That took a while to develop that habit or attitude. I was on the swim team, and so that was my primary extracurricular activity. I was on the swim team, and I was a state qualifying swimmer for my junior and senior year, and was on the relay team that I think was 13th each of those 2 years, and then I was the 15th in the backstroke. That was my stroke there. Also participated in band and marching band all the way through high school, and then played the saxophone and gave that up after high school. I didn't see a future with that.
Okay. So what were your dreams in high school? What did you think that you were going to do?
You know, I think it's another one of those situations where they may call me a late bloomer. I don't know that I really had any specific dreams at that point, even though we were married immediately after high school. I knew I was going to go to college, and I did, of course, and we did go to college. But I really didn't have the wake-up call, I guess, until my junior year in college, where a number of my friends, and it's interesting a little bit, former Justice Baker, of course, and I are grade school classmates. And so he was living with a good friend of mine, Rick Soll, high school classmate, junior high classmate, and a person by the name of Mark Schreiner. And we're all sitting around talking about what we're going to do with our lives after college, because that can't be the ending point. There shouldn't be the ending point. And they all had very, very specific ideas about what they were going to do with their life. And so Justice Baker was going to go to law school. My friend Rick Soll was going to go to law school. Mark Schreiner was going to go to dental school, which he did, and he's just now semi-retired as a dentist. And then I looked at myself at that point and said, I don't know. I'm not sure what I'm going to do. And so that was that was really a defining moment for me where I realized, this is not just a game. You have to continue to move forward. You have to have some type of goal or life at that time. I had the desire to go to law school, but I really didn't believe that my grades were good enough at that time to go to law school.
So where did you go to college?
So I went to 1 year at the University of Colorado. My wife and I and a young daughter moved out to Boulder, Colorado at that time. 1 year at the University of Colorado. That really wasn't a very positive, family-oriented environment out there at the time. And so after a year, I transferred back to the University of Iowa and then graduated with a Bachelor of Business degree from the University of Iowa. And then, as I said, there weren't that many jobs available at that time, or nothing that was very interesting. And so then I proceeded to go to Loyola University of Chicago and receive my master's degree in industrial relations from Loyola. And so my first career was really, I liked business and I liked to be involved in business, and I also liked the human resource aspect of things. And so that was going to be pretty much my career path at that time. And then that was during that time that I did then decide I was going to apply to law schools. I always tell the story that it was another defining moment, where you make choices in your life about what you're going to do. And I was working for the Gould Corporation at that time, which was a Fortune 500 corporation, and they were going to transfer me to Atlanta, Georgia, to work at a plant down there and work for a year under another gentleman. And then I was going to become the plant personnel director in Tucker, Georgia. And so it was at that point whether we had to decide whether we wanted to move to Georgia and follow that career, or whether I was going to go back to law school, which I ultimately went back to Drake Law School then.
So the state of Iowa benefited, but the state of Georgia lost out.
I suppose that's one way to look at it, but...
What did you do for the Gould Company?
I was a regional, or actually I was a divisional personnel director, and so I had a boss. I was the assistant director for the region, so we worked for a $200 million division of the Gould Corporation, and he handled, we both handled doing personnel policy handbooks. We opened up a plant in Wilmington, North Carolina, and they had a person that was going to be working there, but then we assisted them in establishing all the personnel policy handbooks, grievance procedures, which I had done with the Illinois Hospital Association before I joined them. And so that was my level of expertise there.
I'm assuming then, because of those types of things, then as cases, after you became a judge and before a judge as a lawyer, that those types of cases were kind of in your wheelhouse?
Yeah, they were, and I loved labor relations. I had done actually counter-organizing for labor unions. So with the Illinois Hospital Association, then again, I had a boss there as well. But we went out, and when unions started coming into rural, smaller county hospitals, city hospitals, then we would go and talk with the people, talk with the administrators, and convince them that they didn't need a union. And so we would do counter-organizing efforts for the labor unions. And fortunately, my boss was very, very good, and I learned a lot from him, and I really enjoyed that. We never did lose an election, a union election, which was, a positive thing. Mm-hmm. But it was also a very important learning exercise, because in the older days, hospital administrators could just simply act as dictators, and that's what we saw when we went into these hospitals. They had taken advantage of the employees. They had ruled with an iron fist. No rules, no regulations, no personnel policy handbooks, no grievance proceedings. So people didn't feel respected, and they didn't have to be, because they were completely autonomous and could do what they wanted to do. And that was a really important part of counseling, I guess you would call it, with these individuals, because they were strong, older men at the time, all older men at the time, and they were used to being in charge. And when you come in and tell them, well, you're going to have to give up some of these powers and responsibilities because, or you're just going to deal with the union, you choose. And so they did change, and so you did see a metamorphosis in these individuals, and that was always rewarding. We defeated the union, but at the same time educated them and then made it possible for the employees to have a personnel policy handbook, a grievance proceeding, and that was kind of the main thing I did, both for the Illinois Hospital Association and then with opening up of new plants, making sure that all those types of policies and procedures were already in place, and so you have a happier workforce and a more productive workforce.
So in the NCAA basketball tournament, at the very end of the tournament, they have a song called "One Shining Moment." Mm-hmm. And so from your career prior to going to law school and working for Gould and that, can you pinpoint kind of a shining moment at that point in your career?
I really think the most enjoyable parts of those were, frankly, the elections, the NLRB elections, were the defining moments when you start out and you're behind because they're already organizing. They've now already set an election when they call us up. And that was probably one of the most enjoyable things that I did in that career. Went out and did training at hospitals when I was with the Illinois Hospital Association. Went down and did training for supervisors in North Carolina primarily, because I was only with the Gould Corporation 6 months before I went back to law school. And so I think those were, again, two of the most defining moments. I enjoyed labor relations, I enjoyed business, I enjoyed working with people, and that was a good potential career opportunity if I wanted to.
Now, I know that, we've known each other for a good long time, but I know your father was a physician.
Yes.
And I think your mother was more or less a homemaker.
Yes.
And why not medicine? What prompted you to go to law school?
There was just never any strong desire. And it wasn't really his schedule, because I think he was always very well respected back in that day too. He was a general surgeon, but they all did rotations, and so he would be on call all the time. It's not like it is now where you have specialized medicine, specialized emergency room doctors. And so there would be many times where we would be going to be heading out on a family vacation, and he'd have to go on call. And so you just put your vacation on hold for a day or two or whatever it took. I did have the opportunity to go observe a couple of operations with him before he retired, which was also really, really interesting. But I never had that. My older brother, Randy, has now retired as a nurse anesthetist, and he's as close as anyone. My older brother, Gene, is a retired social worker, and he never pushed for that. And that was one thing that I, having just spent the weekend with my brothers, we just always talked about, is that they were never pushing. They just had high expectations for you, but they more or less guided you, but didn't tell you what they wanted or expected you to do. And I think that's carried over in our families as well. So it was never pushed into that direction.
So you move forward and you decide whether it's to be like Justice Baker or to be like Rick Soul, that you want to go to law school, and you ended up at Drake.
Yes, that's
correct. Why Drake?
Back then, they had a conditional program which allowed you to come in and try. They came in the summer, you took 2 courses, and if you were able to do that, be successful at that, then you were admitted, you were admitted in the program. So they called it the conditional program, and I know they can't do that anymore. They don't do that anymore, but frankly, if I hadn't had that opportunity, I wouldn't I wouldn't have a legal career. And so I've always been extremely indebted to Drake Law School for giving me that opportunity. Some people criticize the program and some people don't like it, but I can only tell you from my own personal experience, if it wasn't for that program, and at the time, as I said, I was either going to be transferred to Georgia, and so I moved my wife and at that time 2 children to Des Moines, Iowa for the opportunity to try to be successful in law school. And of course by that time I was dedicated enough and disciplined enough that I was not going to fail, and I didn't, and the rest is history, as they say. And so I've always been thankful for that opportunity to do that, because I wasn't going to get in anywhere else, even though by that time you understand that you have the capability of doing it. And I tried to convince them that just was not possible at that time.
Yeah, as a conditional graduate myself, as well as Judge Mullins on the Court of Appeals,
Yes.
it gave us all an opportunity.
Yes,
So
it's the second chance that we needed to, maybe for me anyway, I'll speak for myself, to mature a little bit more, realize how important it is, and knowing Judge Mullins and knowing you both as I do, it's just, we were so dedicated and committed to doing it at that time that we were not going to be, it was scary, but we were not going to be denied at that time.
when you started law school after the summer program, obviously you got in, was there a particular area? I mean, did you gravitate back towards labor law?
I did not.
Or was there something that really piqued your interest?
It did not. I think as part of my growth in that particular area, I wanted to practice law. That's all I wanted to do. So I wanted to have more of a small town practice. I never viewed myself as a significant litigator, but I wanted to just simply help people. And I've used this example during my interviews, judicial interviews, but when I left the Whitfield law firm when I was clerking there in law school, Alan Whitfield gave me advice, and I've repeated it 50 times, and you've heard it before as well, I'm sure, and others have, but he always just said that, a license to practice law, and he said, just remember this, a license to practice law is a license to help people, it's not a license to make money. And I've always tried to keep that in the back of my mind, is that you can go out and to help people and to be a positive force in the community, I think. And so that's, I didn't have any specific area that I wanted to concentrate in. I always liked business. It was a 4-member firm. I didn't work for a large firm here in Des Moines, which would have more of a specialized area. It was a real general practice, and that's what I did all the time. And I enjoyed that. I liked that.
Do you remember your very first case when one of the partners gave you a file and said, have at it, or your very first client, or anything that sticks out with that very first job?
No, I think I was just, frankly, so excited just to have face-to-face with an actual client that I don't think I can't tell you who it was or what it involved, but I just really enjoyed, the experience of working with people, and they gave me the opportunity to do it. They were good mentors. You learn from everyone as you've gone throughout your career, and they did a good job of doing that as well, and watching me and giving advice such as, don't ever put anything in a letter that you wouldn't want on the front page of our local paper, the Waterloo Courier. And so you can be aggressive and you can be forceful on behalf of your client, but you can't be saying things, I don't believe, and I never did do that, and I took that lesson to heart all the way through. Same thing with our opinions when you become a judge. You don't want to say things to embarrass either the attorneys or the clients. I just never have done that, and I don't embellish opinions. I've never embellished opinions. I don't embellish pleadings. I try not to. I'm really factually oriented, I think, And that's where I concentrate on the facts, because to me the facts drive the case. And the facts are going to, we all know what the law is, but the facts, you just got to be able to make sure the facts either fall into that or they don't fall into that, or so that's what I've tried to do.
And the firm in Cedar Falls, Waterloo area, was it a general practice firm?
Yes, it was.
So
Very
you were
small-time
doing
general practice. We did everything.
maybe a divorce one day,
Yep.
maybe a dog bite case another
Exactly.
day.
Yep. Not very much. I was hired to do a lot of the litigation there, but I have to admit I'm not sure that I was all that successful. And what you learn, of course, through any practice is you either have to do it and do a lot of it, or you better get out of it. And I did some work comp, I did a couple of small personal injury claims there, but once I got to my second firm, and then once I went out on my own, you just realize you can't be all things to all people. You try to be, and when you get out of law school, everybody expects you to know everything about all aspects of the law. And I think part of the maturing process as an attorney is that you realize you can't be, and you need to get the people to someone who handles that particular kind of case. And so I think through the first firm, we did a lot of collection work. We represented a lot of small businesses. One of my partners, I should say, did a lot of farm work. You know, I never did any income taxes, but he did all farm tax returns. He had a lot of farm clients. You know, Ann Bergstrom, who was a partner of mine at that time, did a lot of the divorce work. And so I didn't do a lot of that. That came later on with going to, with Chuck Hinton, and then having them want me to do the IOLTA program and represent low-income people in divorce and domestic relations matter. Then that's when everything, I started developing an expertise in domestic relations matters, and literally hundreds of divorces and domestic relations matters. And it's not an area that I particularly wanted to get involved in because of the emotional aspect of it, and it's very, very difficult. And but you know, I was hired by the IOLTA Commission to do that, and I did it. You develop an expertise, then word of mouth, otherwise people start coming to you, and you know, you got to work. And I was a sole practitioner, and I developed an expertise in that, maybe by default, but it's worked out fine. And certainly when you become a judge and you've handled, you know, hundreds of divorce cases, it's not a big surprise to you when you handle your first divorce trial.
So how many years were you in a firm before you made the decision to go out on your own? There was one firm, then you said you went to another firm, and then you went on your own.
I was about 8.5 years, then I went out on my own. And I considered doing it after the first firm, but I just didn't feel I was quite ready for it. And so I did go to with Chuck Hinton at the time, and spent 2.5 years there. And then I decided that I was going to go out on my own. And you know, there's always a lot of, there's not really tension, but there's always a lot of, maybe you think you weren't compensated enough, or maybe you think that they don't give you the good cases. You know, it could be a lot of those little nuances that are there. And when I went out on my own, I simply decided that it's just going to be me. You can't point to somebody else and say, oh, well, you're not appreciating me like I should, or that I'm not being compensated. Now I can only blame myself. You know, if you aren't successful, you can't blame anybody else. It's all on yourself. And so I finally made that decision after about, I think it was about 8.5 years I did that. And then for the last 11 years, just short of 12 years, I was a sole practitioner.
So you hang out your shingle, and who do you hire as a secretary?
Oh, I took my secretary from the second firm. I had hired her when I joined the second firm, and then she went with me when I went out on my own. And so she was with me for about 10 years, and then ultimately the last year or two before I went on the bench, my wife Diane was my unpaid legal secretary and receptionist. And
who was the boss?
well, as Diane said to be professional in this interview this morning, my wife, and so I said there was only 2 times where she simply walked out of the office and said, "I don't have to take this anymore." But so we had a good balance. It was okay. I learned from that experience, and she did as well.
And you haven't worked together since, right?
Yeah, that's right. So that was fine, and she's very, very good, competent as well, and I couldn't have found anybody better to do it. Plus, you're both. She understands and appreciates she understands a little better the trials and tribulations of working in a law office at that time and the pressures that you have. And that also makes it a little bit easier when you try to go home and explain something. She already knows what's going on.
Well, just speaking from experience, there's a special place in heaven for your wife.
Yes, there is.
So after 12 and a half years, then, did you always aspire to go on the bench, or did you think, well, if those people can do it, I can certainly do it, or what precipitated the idea of going to the district court?
I'm not sure I can tell you exactly what the first time that I, applied for the district court. It was probably several years after that, and working up in the first district like you did, we have some great judges up there and people that I just respected so well that I think are tremendous judges that have the temperament and demeanor, which to me is just so important for a judge. People like yourself, people like Judge Bush, Judge Mahan, just has that kind of temperament and demeanor, gets the work done, knows what they're doing. Everybody's intelligent, but they just have that little extra. I just decided I think that's something that I could do, and I remember speaking specifically with Judge Bush at one event and telling me I was thinking I may want to do that, and then he was encouraging, and whether he meant it or not, he encouraged me to go ahead and apply, and I did. And just as we all understand with this process is that it's not an easy process, and you have to have the stamina to do it. You have to have the determination to do it if that's really what you want to do, and by that time I had decided I wanted to do it. I applied 2 times that I can recall, and then didn't get it, of course, didn't get out of commission, didn't get appointed. And then I took a couple years off, and that was when our youngest daughter, Tara, was in high school, and one of our friends' children had been killed by a drunk driver at basically the same age. And I just decided maybe that wasn't her junior and senior year of high school. That probably wasn't the right time to do it. So then, after a couple of years off, then she was in college, everything was fine, then I did apply again, and then that time I was appointed that time. So the third time the charm on that one.
Do you remember who the nominee was, the other nominee?
Brad Harris.
Brad Harris, okay. Who's now a district court judge.
Who's now a district court judge as well. Okay. And so it was between him and I, and that's what I think happens so often. I mean, Brad Harris is certainly a very, very good qualified individual and judge, and that's what I think we all learn to appreciate so much during these processes, is that everybody out there is super, I think, is really intelligent. Everybody out there has their own story and has their own path that got them to this point. And sometimes you don't appreciate that. You just think, oh, it's a done deal and they're going to get it. And that might be true under some circumstances. But by and large, if you go back and start looking at other people's resumes and qualifications, you go, oh wow, wow, that is really impressive. You like to think you're impressive. You know you can do the job, but it gives you a better appreciation and a better respect for your colleagues, I think, not only as lawyers, but also judges, when you realize that they're all going through the same process too. They all have a lot of such strong attributes that they bring to the table as well. And that's why I do think we have a great a bench here in Iowa. But it's hard sometimes because it's an ego deflator, as we all know. And if you don't have the stamina, and I've advised several people now, which you would know as well, when they didn't get out of commission and were complaining about it and said, oh, I don't think I'm going to apply again. And you say, well, that's up to you. You have to either have the desire to do it, you have to have the stamina to do it and make sure your ego is okay. Otherwise, you shouldn't try, because you're going to get disappointed, I think. There's going to be disappointments, and I always hesitate because it doesn't work for everyone. So you encourage them and you think they'd be great judges, but it doesn't work for everyone. So I try to be a little cautious about that, but I think overall, if you persevere and you maybe have your ego beat down a couple of times, I do believe it makes you stronger and more determined to make it.
So the third time was a charm. That was
Yes.
Governor Branstad?
That was Governor Vilsack.
Okay.
Yes.
And what year was that? Do you remember?
That was in 1999.
Okay. All right. So how did life change from being a practitioner to going on the bench? I mean, your jokes get funnier and all that kind of stuff. But what
always
else
happens.
changes?
I think so much of it changes. It's just a whole different mindset. And when I went on the district court, you ask about the strong desire to do that. I think I'm one of those individuals who always likes to do something different and expand my horizons and explore different things. And so, being a judge it is completely different. It's never what you expect exactly it's going to be, but that's exciting and terrifying at the same time. So it changed from the standpoint is, as I mentioned earlier, you try to limit the focus of your practice sometimes because you're dealing with areas, you don't want to deal with areas that you're not familiar with. Well, I had really never done any criminal law to speak of before I went on the district court bench. And so that was a whole learning experience. I had been in the county attorney's office as an assistant county attorney in the civil division, but I still couldn't have done any criminal things. So I hadn't done any criminal law. So that was a sharp learning curve. As you know, when you get in and you start doing pleas and sentences and motions to suppress, I'd never done any of these things. The other parts were easy. You're doing a divorce trial, you're doing collections, or even personal injury lawsuits or trials. You're able to do that, but it's a whole different mindset. So I really was excited about that. I know people see it as being a little bit more cloistered, but I've never been overly concerned about that because I don't have so many people that are going to ever take advantage of that. They're not going to take advantage of my friendship. I'm still going to be friends with these people. I'm still going to, do fantasy football league. I'm still going to go play golf with these people. And we don't talk about business. It's not that much different, or I didn't find it that much different than I found it before. But yes, you are. You're in a different position. There's so many different expectations that people have of you, and you have to be mindful of that and make sure that you don't let it go to your head. You don't, and I don't believe I've ever had that type of problem, but I've always attempted to always maintain the humility that I think, again, a good judge is required to have. And then you have a different group of friends that you develop. And so with yourself and with Judge Bush, and we were all active district court judges up on the 4th floor of the Blackhawk County Courthouse. You develop different spheres of friends and different activities, and you would never experience that if it wasn't being a judge yourself. And so I didn't find the transition all that difficult. Probably not as much as then going to the Supreme Court is a little bit different then.
So you were on the district court for how many years?
Just short of 12 years.
Okay. And is there a particular case or person, or that if you had to whittle that 12 years down, that will always go with you, whether it was a funny person or a sad case, or is there something that you took with you case-wise to the Supreme Court?
Well, this is always the example that I give as a most memorable case was the Michelle Kehoe case, and she was the woman from Iowa City who came up to the 1st District outside of Jessup and killed her one child out in the woods by cutting the child's throat, and then attempted to kill her other child and by cutting its throat, which the other child, thankfully did not die. And then she attempted to commit suicide herself by cutting her own throat. And so that was probably, the most unique case that I've ever handled. Besides the obvious traumatic effect that the case has, we did try that case, and I was especially assigned to hear her case. It also had so many different permutations because of the insanity defense, and so insanity, that was maybe my only case where insanity had been used as a defense. And so that went on for quite a long time, and then the claim to fame, I guess, is that this was all live streamed from the Grundy County Courthouse. I had to do a change of venue, but it was all live streamed from the Grundy County Courthouse by the old Court TV. And so they were parked in the lawn of the Grundy County Courthouse, and my wife would tape it. And I don't like watching myself, of course, and hoping that you don't look too badly. It was just such a different experience, one that I would never ever have. Most people never have it. I had it once, you'll never have it again. But it was just such a unique circumstance. And fortunately, the legal analysts for Court TV were kind to me and thought, oh yeah, I think he ruled right, whatever they do. But it's always, at least, it makes you feel a little bit better when they don't wonder what you're thinking when you're making your rulings and things. So that was probably that was kind of the highlight of probably the district court career.
This is in the Iowa District Court in 4, Buchanan County, State of Iowa, plaintiff versus Michelle Lynn Kehoe, defendant, case number FECR 075435, verdict form, count 1. We, the jury, find the defendant guilty of murder in the first degree, dated November 5, 2009, by Anthony L. Buter, presiding juror.
When you were in practice, you said that a friend of Tara's was killed by a drunk driver, and then as a judge, you see that type of trauma, you see child abuse cases, you see issues in divorces and custody cases. How is it that you cope with that off the bench, or do you always take that with you?
Well, you always take it with you to a certain extent, but you can't. You just can't dwell on it. You realize how, frankly, evil people can be, and it's always in the back of your mind, but you can't let it drive what you do either as an attorney or as a judge at any level that you are. And that's what I respect about other judges as well, is the touch of humanity that I think you do bring to your position. And those are the judges that I respect the most, is that they bring this humanity. We all know it's out there. You know, we know this is going on, and probably the most traumatic ones for me are the child sexual abuse cases. It's so hard to fathom people that are out there like that, but you know they're out there, and that's where you get, you gain a whole new respect for, I think, for the entire judicial process, starting with law enforcement and investigating these types of incidents, the Department of Human Services that gets involved. It's a complete team effort to work through this, and I think knowing that you're not alone, I mean, you don't have to do this alone. You do it with all of these other professionals, helping you. I think that's just what makes it easier to deal with that. And then I've just always said throughout my, and when I go and talk to students, as I know you have as well, they say, well, what happens? How do you even cope with these things, as you're intimating? And all I tell them every time is that I just do the best I can every single day. And I never have, I can look myself in the mirror every single day and know that I did the best I could. Is it always right? Of course not. But in my mind, I think it is right. I can look at myself in the mirror and I can sleep at night, and I do, because I know I just did the best possible job I could. And we had the swearing in last week of the judges for the Court of Appeals, without,
Fear or favor.
Fear of favor, and what it is. Thankfully, I haven't had to repeat that for a while. But you just do the best job you can every day, and people are going to criticize you, and that's okay. That's their privilege to do so.
So about 12 years on the district court bench, and of course, we were working together then. Judge Bush was working. We thought, we were kind of the A team of of the courthouse, and then all of a sudden, what prompts you to think, no, I've had enough here, I want to go to the Supreme Court?
I think it's that same desire to do something different. I think it's, as you know, it can be a grind on the district court, and Black Hawk County, primarily up in the 1st District, it's a busy county, and it's a constant grind, just like it would be, I'm sure, here in Polk County. It's a very strong grind. Once you've done 25 or 30 drug cases, they all become the same, and we all love to do jury trials, of course, but once you've done 25 or 30 of those, and in my case as well, they're interesting, but they're hard when I'm talking about like divorces. When you've done 500 divorces, you sort of change the names, you try to calm the attorneys down, you try to calm the litigants down, and just make sure they know, you're just going to do the best job you can, but I'm not the person who created this problem either. So to me, it was really just trying something different and doing something different, and that's what I think I'm always, wanting to learn and create or do something different. And so that's when I first applied, and you had been applying as well. I know you probably, when they do your, when you'll do your interview, but it's just looking for something different, and that's about the best answer that I can give you, is that it's just something new, something different. It is a whole, as you know, it's a whole different way of practicing law, but it's another way, and I know I've said this in interviews, because that took a while as well on the appellate.
Didn't get it the first time?
No, I think there was like 5 times that on the Court of Appeals that we're well aware of, and that's another one of those examples where you spend so much time and dedicate so much time and effort, and you're pumped up, you know you can do the job, and then it's like, well, you're not out of commission this time, you know, and so that happened, I think, at least 4 or 5 times. I don't know the exact number. And a couple times I did get out. I did have an opportunity to interview with Governor Culver, but wasn't appointed. And then, you know, 2 or 3 other times you're not. And so from that standpoint, it seems like somewhat of a random process, and so you have to deal with that. You know, well, I got out this time, but I didn't get out this time. What
changed?
What changed? You know, I don't understand. But then you continue to have to persevere and do that.
So the Supreme Court opening comes along.
Yes.
This is Governor Branstad then?
Yes,
Okay.
that's correct.
Is that your first time to apply for the Supreme Court?
Yes.
All right.
But with that process, and
It's the same commission, though.
it's the same
Okay.
commission, and so having gone through probably 2 or 2.5 years, really with the same commissioners, and I've tried to let lawyers know as well if they're applying for those positions. People have to get to know you, you know, on your paper. You give them a big paper, and then you try to do your personal interview with them if you can, but they don't really know who you are, and you're, I'm sure, saying all the right things to them as well. And so it really did, you know, I'm just speaking for myself, I really do think it takes a year or 2 or 3, and they had a number of openings with the Court of Appeals, and then the Supreme Court openings occurred. And by that time, they pretty much know who you are. And I do think that was probably the greatest significance. You know, for whatever reason, some people, you know, they don't want to apply for the Court of Appeals. They only want to apply for the Supreme Court. And I don't personally understand that, but that's okay. Well, then when we had the 3 openings, and you had 60...
That was Baker and
Chief
Stride
Justice Turnus and Stride.
Turnus because of
the retention election in
Barnum
2010.
decision. And
Yes. So then, first of all, we do have 3 openings, and so you're going to have 9 people that are going to be going to the governor's office. But then you also have 63 applicants, I think is the right number, which was significantly higher than what we had ever seen for a Court of Appeals opening leading up till that time, like 2 or 3 times almost. And so I felt like it was important to, if you want to call it momentum, you know, at least they knew who I was. I would apply for this, you know, what could be, you know, the highest echelon is the Supreme Court.
Right.
And, you know, fortunately did get out of the commission at that point, did interview with the governor on several occasions, and then was appointed.
So it was you, Judge Mullins, and who was the third? Do you remember?
Well, there were 9 of us, and I'm not sure if I could tell you all 9. The professor from the University of Iowa was one of them. I think maybe John Gray from Sioux City?
Yeah, there would have been 9 because of the 3 openings. I was thinking there were but
Yeah, there were 9,
and you had a second interview.
yes, I did have the second interview. I strongly believe that we need to have district court judges on our appellate courts. I have said that, and I've been a pretty strong advocate for that. Partially it's self-interest because we are district court judges, but I also believe that that gives you a little different perspective. Now, everybody is going to have their own opinions about whether that's more important on the Supreme Court, less important on the Supreme Court, more important on the Court of Appeals or not. But I just think having been there, having done that for 10 or 12 years, or you were perhaps longer when you were appointed, you just have a different perspective on things. And now I've come around a little bit more. No, it doesn't have to all be district court judges. It's important to have diversity, and it's important to have differences of backgrounds, because I think that just adds, you know, to the tapestry of your opinions and how you interact with each other. And I do see that as being so important. And I'm just reading more into it than maybe I should, but I think the interviews that I believe Judge Mullins and myself had was to decide which of us, as district court judges at the time, were going to be on the court, because we really did not have a district court judge for a long time with Chief Justice Cady, of course, but it's been probably 20 years since he was a district court judge, and so I believe that's what it came down to.
So the second interview is with you and Judge Mullins for the Supreme Court.
Yes.
And you get that. Judge Mullins becomes on the Court of Appeals.
That's right.
But you had a history with Judge Mullins.
Yes. Mike and I are classmates from Drake Law School, and his wife and my wife were friends, even back then, and lost track of each other over the years. But when I did become right after I became a district court judge, he stopped in and saw me at the Blackhawk County Courthouse, actually, and congratulated me. But you could just see that it was just a matter of time before he was going to be a judge as well. I graduated at mid-year because I felt like I needed to get out of law school and start practicing law, and he stayed around, but again, Mike was editor-in-chief of the Drake Law Review, and so he probably could have gone early, but you can't do that in that position. You have to stay the whole year, but he could have gone earlier, I know, as well.
So you, Judge Mansfield, and Judge Waterman are appointed
Yes.
on the same day. You all three have your investiture over
Yes.
at the Capitol building, and what's the big difference between the district court and the Supreme Court? I mean, obviously the volume of cases is different, but
Right.
what was the most startling difference that you noticed?
I say this with all sincerity, that it's just the sheer volume of the work, and it's not the cases like the Court of Appeals publishes every year, 1,200 cases. I'm not sure the number, you can tell me, but and we try to limit ourselves to about 100 to 120, and it takes a complete mind shift, because as a district court judge, you're expected to get you're churning the work. You have to get the work done, and I know. Again, the good judges, they get their work done in a timely fashion because the clients and the attorneys expect that. You have to get your work done, and we have 60-day requirements, of course, as a district court judge. We have no such requirements on the appellate courts, but most of us have our own self-imposed limitations in doing that. And you may have found this as well on the Court of Appeals, but now, as a district court judge, you just decide everything. And sure, we can go talk with each other and bounce things off, but ultimately, I just make the decision. And I don't use this term lightly, or I do use it lightly. You're just king for the day. Whatever I say that day, you can think it's a totally irrational decision. It really doesn't matter, because whatever I decided that day, that's what's happening. And then, I'm going to appeal. Okay, you appeal my decision, but I'm king for the day, and this is how I get to decide all that. The real difference in an appellate court, whether you're working in your court or a panel of 3, or at the Supreme Court, you're now dealing with 6 other people, and they all have an input on every case. Okay, it's not. I can't just say, well, that's what I'm going to do, and that's what makes sense, and I'm going to write my opinion, and that's done. We conference cases for hours and hours and hours, depending upon the issue. It's exhilarating from one standpoint, because you get to hear everybody else's thoughts, and they're coming from different perspectives, and that's the diversity that's really, really interesting. But by the same token, that can be extremely frustrating. You don't get 80-page briefs and amicus briefs. You don't get all this paperwork at the district court normally. It just simply takes me a lot of time to read through all those briefs and try to absorb it. You're dealing with, I believe, overall, more complex issues. You're dealing with constitutional issues. We don't deal with constitutional issues. We don't really deal very much with statutory construction. And so these are all, again, as I talked about, your mind has to shift when you go to the district court bench. Now we have an additional shifting on the Supreme Court, and now the weight of the decisions perhaps is a little bit, not perhaps, it's just greater. I mean, now you're making the law. Not like the legislature, don't get me wrong, but you're interpreting the law and you're deciding what the law of the land is going to be. And that's, it's an awe-inspiring, responsibility, but by the same token, it's a big responsibility. And you want, right, everyone wants to have their opinion heard, and that's the way it should be in a collaborative court. Having 3 of us come on at one time, that adds its extra. Now you've really had a pretty significant change in the turnover of the Supreme Court. I think that took a period of adjustment as well. That's just the nature of organizational behavior, but that was challenging, I think, as well. And just the sheer time that it took to do these things. We do further reviews, as I think I mentioned to you at one time, and we used to have to carry big bank boxes full of files to do the further reviews and flip through and get the further review applications. And I remember one of the very first times, and Diane says, well, what do you got to work on today? I said, well, I'm working on further reviews. I said, I thought I was a fast read. I thought I could go through this pretty quickly. I said, this will probably take me about 3 or 4 hours. Well, about 10 hours later, I'm still pouring through these further reviews because they're all, they're pointing out very significant and important. And if you're not used to that, it takes me a lot of time. That was just me.
So when you were on the Supreme Court, some people compared you to Justice Kennedy because you weren't, and some people thought there was a Republican or a right-leaning component of the bench and a left-leaning component of the bench, and then you were kind of in the middle. Did you ever feel like that, or was that more just kind of what you had heard? You were the swing vote.
Yeah, and I probably that first year or so, I think that's what they, when they do the analysis, how Zager goes, so goes the court, because I was the swing vote on a lot of those. I've never ever attached myself to any type of leaning, I guess is the best word, with whether I'm left-leaning or right-leaning. I've never been a political being. First of all, we couldn't be. Once you become a judge, you can't be involved in politics. I never was involved even before that very much in politics. I just don't like to be labeled that way, and because I don't think it's fair. Now, I don't know, maybe things are changing. We all know that things are changing a little bit on the U.S. Supreme Court, and maybe it's just my naivete thinking that it wasn't always that way, but to me it seems to be getting worse.
The political component.
Political aspects of things, and I just never attached myself to any political dogma that was out there. I don't know that, this is just my personal opinion, I don't think that really should have any place in being a good judge, and that's just not who I am, and that's not what I personally look for in a good judge. I want somebody who's going to objectively look at all the facts, know what the law is, but never under any circumstances have somebody think that, oh, well, he's that way, so he's always going to rule that way, or he's always going to vote that way. And that did, over the course of a couple of years, that did fade away. I was not the swing vote anymore, but if I feel that it's necessary, then I'll write a dissent or a special concurrence. I was not one who felt the need to write all the time because, yes, it's my opinion. Yes, I understand I'm a member of the Iowa Supreme Court, but just because this is my way of thinking on something doesn't mean that everybody wants to hear it. So I'm much more restrained on that unless there's something I just feel strongly is not correct. And that's an art that people have to develop too, I think, on your court and on the Supreme Court is, just because you can doesn't mean you have to write on everything. And is it really going to matter? And am I really going to enlighten anybody by my personal opinion on this and how it should have happened? And so the ones that I concentrated on when we had our juvenile sentencings, typically wrote on all those because I felt very, very strongly about that. Some of our search and seizure cases, I'm going to write on because I feel very, very strongly that the majority in those particular cases, I suppose, I just didn't agree with it, and I couldn't agree with that, and I didn't think that's what the law said, and I think we're, expanding it beyond reason. And so that's, again, my philosophy, I guess, is that, you're right when you really have something to add, and it really adds meaning to it.
If I remember, you're 68?
66.
66, I'm sorry. I may have to edit that out. Huh? So you're 47. No, so you're 66. You graduated from Drake Law School in what year?
80, well, technically 80, December of 1980, and then I passed the bar in January of 81.
Okay, so you've been a lawyer, you've been a district court judge, you've been a Supreme Court justice. What kinds of changes, whether they're negative, whether they're positive, what kinds of changes have you seen since those early days in the Cedar Valley as a new practitioner with all the knowledge to a retired justice from the Iowa Supreme Court?
Well, I think the most difficult thing now is with the technology that's there and with EDMS, you've really lost a lot of that. This is just me speaking as well, but you've lost so much of that interaction and personal communication and interaction with people. Everything's done electronically, and it's a great thing, don't get me wrong. It makes it very, very convenient for everyone. But I was at, up in Waterloo with, the Black Hawk County Bar Association, a week ago. And this is just the way it is. There's so many new young attorneys, and when you first start, and even as you're going through those first maybe 10 or 20 years, you know everyone. You know everyone, that you know the new young lawyers that come in. You just have an ability to work with them and to deal with them, maybe have a telephone conversation with them. And I think we've really lost that. And that's really, really too bad. And I was asking somebody, because I did so many divorces, I said, oh, well, is Sandy still doing domestic relations up in the courthouse? And they said, oh yeah, she's still doing that, and she's been doing it for probably 35 years, I suppose. Mm-hmm. But I just question, how much interaction do people even have with those clerks who are just invaluable as a young attorney, to get to know them. They'll protect you. You learn about them. You become friends with them and know what's going on in their lives. You don't have that anymore. The same with the with pleadings. You don't go down and file it at the courthouse. I don't think they even go down to the courthouse and introduce you. That was a great thing in the old days. Your senior partner would take you down there and introduce you to all the clerks, so you could start developing your own relationship, and they could put a name to a face. I don't know that happens anymore. There's probably no reason to. But I think we missed that human contact, that interconnectedness there. I think same with just trials. I know having civil trial attorneys around, they're bemoaning the fact that there's just no civil jury trials anymore. Everybody's doing mediation. That's good and bad. For clients, they love it if they can get the case resolved without the necessity of a formal trial and experts and the time constraints and expense that's involved in that. But as a trial judge yourself, that we love to do those. Those are the enjoyable things that we love to do is jury trials, whether it's criminal or civil. We love doing jury trials, and then you're not seeing those so many times, which also I think makes our caseload a little bit on the Court of Appeals and on the Supreme Court. you're not really analyzing a lot of trials. You're analyzing procedural disputes or statutory interpretation disputes. Obviously, constitutional disputes all the time now that come up at the Supreme Court primarily, but you're not looking at cases like that. I know in my own case, our daughter Tara, she just had her first jury trial, 2 weeks ago, and she was so excited. She's having her first jury trial, and I think she's been in practice now for probably, maybe, don't quote me on this or I'll have to edit this out, but 12 or 13 years, and she does all the prep work and gets up there, but the case is settled, and she never has gone to trial until then. She was just ecstatic to do it, and then so high when she was done with it, just to have had that experience. And so I think there's not much else you can do about that.
Let me ask you another question. And you lived in Waterloo, you practiced in Waterloo, then you came to the Supreme Court, and you moved to Des Moines.
Still lived in Waterloo.
Well, you still lived in Waterloo,
yeah,
okay. And Tara is
Yes.
an attorney in Des Moines.
Yes.
And I was at a graduation just this last weekend talking to somebody from Waterloo, and they're having trouble getting young lawyers. And everybody wants to come to, not everybody, a lot of young lawyers want to come to Des Moines.
Yes.
And there's a real need for lawyers in small towns.
Yeah.
When you were on the district court, you'd go to Grundy County, maybe a county of 10,000 people. You'd go to Alameda County, a very small in population county. What would you tell young lawyers who are trying to make that decision about the bright lights and all the bike trails and all the nightlife and that? What do you tell them?
That's very, very difficult. That's a very, very difficult issue, and we have seen that in our rural counties. We've seen that as district court judges in these rural counties, and they cannot get anybody to come. If money is your motivation, you can make a great living in these small towns. These people, and they develop estate practices and they develop agricultural practices out in these rural areas. Lots of small businesses are out there, and some not so small businesses are located in smaller areas. You can be successful out there if that's what you want to do. I think it's such an individual decision. If that's your motivation, don't sell that short. As I know now, just recently permanently relocating to the Des Moines area, this is just such a great community here, and it's got everything here, including our daughter and grandchildren. But even if it didn't, it's just everything is here, and it's hard to fight that. I just think you'd get a little bit swallowed up in the whole environment here, and if you ever try, I don't know how you would do that. I wouldn't have the guts to do it myself, to come here and then practice for 5 or 6 years and then put my shingle out, with no client, unless you had one client that's going to support you. I just don't know how you would do that, and I give these young people a lot of credit, although there's issues with that as well, problems with that as well when they don't know what they're doing. So I don't know if I have a great answer for you. I see both sides of it, but being in Des Moines, I just personally would feel like you might just get swallowed up, unless you just want to work at a big firm. Mm-hmm. I know they make a lot of money too, and I don't know what the answer to that is. I know cities have given young people incentives, law firms give them incentives to enter into a rural practice like that. Again, I'm so far removed from a young family. Do you want to raise your family in a small town, idyllic small town, or do you want to raise them in a huge community like this that you're going to have all the opportunities, whether it's dance or soccer or baseball, whatever you'd like to do? It's going to be here, and I don't know if they have those opportunities for your own children up in the more rural areas.
I think you told me that you were able to swear in new lawyers.
Yes.
That had passed the bar.
Yes.
Did you have memories of you being sworn in when you were swearing them in, or what was that like to see all these new faces?
Oh, it's wonderful, and I think it's particularly enjoyable when you have the the lawyers that you now know and their kids are now being sworn into the bar. So that's probably the most enjoyable part of that. I've had the opportunity, we rotate, of course, or we did rotate the full swearing in of the bar admittees, but there's always 2 or 3 or 4 current attorneys whose children have now gone into the, have passed the bar, and that's always just really exciting. I think that's really enjoyable as well.
So you're a senior judge on the
Yes.
Supreme Court, and what does that mean?
Right now, that means that I do all the appellate motions. And so when I asked to be a senior judge, we talked a little bit about the different things that I could do, but the primary one that they want me to do is motion weeks. And so I started out 1 week a month just doing the motions. And what this does is it just means one of the other current justices doesn't have to worry about the appellate motions for a week.
What might be a motion that you would get for an emergency stay or something like
Emergency
that?
stay, interlocutory appeal, those would be more the emergency ones, like a stay, interlocutory appeal. They don't like the decision of the district court. Lots of procedural motions. It could be just extensions of time. You know, Miss Mayberry does all the extensions and she handles all those, and we have 3 or 4 different staff attorneys down there that look at everything and do just a great job. Whether it could be a dismissal of a juvenile appeal because they didn't file the petition on appeal in a timely fashion. It could be, I just did one last night when I got back into town on a second attempt to reinstate an appeal that's already been dismissed by Justice Wiggins, and so they're recommending denial again, which I did. That's primarily what I'm doing. And then with the little bit of the transition with Justice Christensen in the fall, who was able to start right away, but then with Justice McDonald, who started midstream here in March, I think is when he started, they asked me, and they were behind because they were having Justice McDonald look through all that he could all the way back till September, which was a huge responsibility. Then they asked me to pick up another 4 weeks, and so I've been doing it 2 weeks a month. So that's what I'm doing right now. We'll see if they have additional duties and responsibilities that they would like me to do, but that's primarily what they're having me do now. I have a feeling that they like to maybe control things a little bit more, and that's fine. I think we'll just talk to Chief Justice Cady and see if there's anything else he'd like me to do, because I'm happy to help out in any way that I can, and I do think I offer some institutional knowledge then over the last 7.5 years about the court. So whatever I can do, but they like to do things themselves, and that's okay too.
Well, now that you're, kind of at the end of your legal career, and you can do some mentoring for, not necessarily Justice Christensen or Justice McDonald, but maybe a district court judge or something was to call you up. As you think back, were there people, judges or lawyers that really helped you, that you took something away from their advice or the way they presided over cases, or something that you can really put your hands on?
Sure, there's just so many of those, and had this discussion over the weekend with my brothers. Every profession has the good and the bad. I think we were very, very fortunate up in the 1st Judicial District to have just so many that were positive role models of what a judge should be, such as Judge Van Meter, Judge Roger Peterson, Leonard Liebert, who just recently died, Judge Bush, yourself. These are just people, and I'm going to give you the attributes, I guess, that I see in these people that I attempted to model myself after, perhaps, and you bring your own perspective to things, but it's a little bit trite, but the duty of the judge is to make sure you're listening there. And we've also had some judges in our district that, before you even showed up for the hearing, they told you what they were going to be deciding. And I said, well, we can go in and do this hearing, but I've already decided. Well, then did I win or lose? You know, then I'll decide whether I still want the hearing or not. But you know, those, I don't respect that. And of course, none of those names that I've mentioned were ever like that. They always listened to you. They always made sure that they gave you a full opportunity to articulate your position. They were respectful. And, you know, I think we've all run into judges that are not that respectful and judges that don't do that. But I'm going to give you the positive answer. They're respectful to you. They never try to embarrass you in front of your client, even though you may have done something that's embarrassing. They're never going to accentuate that and embarrass you in front of that. By and large, you want to make sure that the clients feel the same way if it's in the middle of a trial, and I think most of them did that, and I certainly did that, and I'm sure you did as well. You just sat there during a 2 or 3 day divorce trial, let's say, and you speak directly to the clients and say, you know, this is really a difficult decision. This was my colloquy afterward. You know, this is not something that I relish doing this, but it's now in my hands because we couldn't get it resolved otherwise, so now I have to do it. I don't like this position necessarily, but I'm going to make a decision. One or both of you is not going to like it, but you know, I'm just going to do the best job that I can. And then, you know, carrying on even further with that, and then being able to, you know, get out a timely opinion that the attorneys and the clients expect some type of, whatever the decision is. Most people just want a decision. So they know how they can proceed with their life or proceed with an appeal. They want a decision. And so it's so important for a judge to do things in a timely fashion. And then again, within your writing, make sure the same thing. There's no real reason for you know, tearing down one of the people, one of the litigants, in my opinion. You don't need to tear them down. You can make a simple comment by, you know, the testimony did not appear credible to the court, something like that, instead of calling them a liar in a decision, or, you know, that doesn't help anything. And so, you know, you look at those individuals that we talked about as being good judges and ones that are not so good. You know, you can see the dichotomy there. I think the sign of an excellent judge is simply their temperament and their demeanor, and even under highly emotional and other situations, whether it's in the middle of a trial or not, just remaining calm. And I think most good judges, and I tried to do this myself, you know, you don't get angry on the bench. You don't, you know, use your power on the bench. Yes, you control your courtroom, but you can do it in a certain manner. And so I always felt, and I've had feedback from clients and from attorneys, is that, and even at the appellate level, it's so important to even hear. I'll never forget one of the very first cases we did on the Supreme Court on the road. We did the Steel Wheels case up in Mitchell County. Right. And so we did it in Mason City. And we took it up there because that was a local case, and we tried to do that as a local case of interest. So the Mennonites showed up, and they were there at our evening oral argument. And it was very interesting, and of course, from their standpoint, it was all the men and boys could come in, but the women could not come in to where the argument was being conducted. So that was interesting. But then we had a little reception afterward, which we always did. I had an individual come up to me, and he was one of the Mennonite people, and he was so thankful and effusive in his thanks, and he said, you know, thanks for coming up here to do this, because if we would have held it in our courtroom here in Des Moines, they never would have shown up. I mean, nobody would have been here. But and then he said, you know, I don't know what your decision is going to be on this, but I know I got a fair hearing. And that's what you expect as a trial judge as well. All I'm trying to do is make sure everybody's heard, as long as the attorneys and the clients feel like at least they listen to me. Everybody feels better. Or if they had any input on the ultimate, I got to say what I needed to say.
Right.
And if I say, well, no, I'm sorry, I've heard enough from you, I'm not going to listen to you, well, then they're already going to be up in arms. And so, even at the appellate level, that's why I do believe that some of these courts on the road allow other people to see these arguments. They know that they got a fair hearing, that their voice was heard by their attorney arguing that case. And he says, I don't care what you decide. I know I got a fair hearing. You're all smart guys. And of course, I think Justice Mansfield wrote the opinion in their favor. But and it was unanimous. I mean, it wasn't highly contentious. But that's really rewarding as well, when you can go out and reach out to people and they are confident, and that's why I always encourage at the Court of Appeals or in the Supreme Court, if your clients can be there, they need to be there to hear and see, how we all conducted ourselves from the bench. And if you cut them off, or if you didn't feel like they got their fair shake, they're not going to respect your opinion anyway.
Right.
So yeah, those are good, strong mentors and my attributes of a strong judge, and those are character traits I guess I've tried to emulate, on the bench, here and as a district court judge as well.
So you have, is it 5 grandchildren?
4.
4, okay. And I assume that as a senior judge on the Supreme Court, you have a little more free time.
Yes. And
you've got 2 grandkids in Des Moines.
Yes.
All right. So what do you see yourself doing? I mean, I don't want to ask you what a regular day is like in your life, but I mean, since you're goal-driven, you've been goal-driven your entire life, you obviously probably have goals now that your senior status and retiring. What types of goals do you have? Or maybe you don't have any. Maybe you just wake up and...
Well, it's been a little interesting. From retirement in the fall, we do have a cabin up outside of Guttenberg. And so the fall was pretty much taken up just by relaxing, going up there, and I love watching football games, and it's fall, and you can just have all that free time. And then I did have my knee replaced right before Christmas, and so the first 3 months of this year has just been rehabbing and doing that. What I would like to do, and what I said I was always going to do, is I do want to volunteer at legal aid. I really enjoy doing the motions because it does keep you involved, and so I'm continuing to work with the appellate clerks of court's office and the staff attorneys that work there. And again, every other week now for the last 3 or 4 months that I've been working with them, and they all do just such a great job. It still keeps you a little bit involved in the cases and what's going on and the issues that are percolating up through the system. So I really, really enjoy that. But I think I also need to go back and have some person-to-person contact. I don't know, I'm a little scared only from the standpoint is I haven't counseled clients, really for going on 20 years now, and I don't want to say anything wrong or do anything wrong, but that's really is a goal of mine as well. You talk about our grandchildren, and we are fortunate now that we are living here full time that Tara's children are now in school. And so they have early release on Wednesdays, and so we pick them up every Wednesday and bring them back to our house, and we play and usually have dinner, and then they go home. There's other times their parents want to go out, and then we just have them spend the night. So those opportunities are, just wonderful opportunities. And now this summer, we've committed to watching them 2 days a week. They have a nanny that Tara has hired for the 3 days a week, and then now we're watching them Tuesdays and Wednesdays all day, and that's wears you out, but it's just great, and they get to spend the night. We've just had one trip of a couple of weeks out to visit our daughter and her family in Salt Lake City, and then my son in Denver, and took till about April or the first part of May before I really felt like I wanted to do long distance traveling. But we want to do some traveling. I always said I was going to buy a motorhome, and we'll see if that happens to travel around. I'm still on the fence about that, but we may do that. I want to do a lot of traveling.
Well, you're a scuba diver, as I recall.
Yeah,
and,
I haven't done that for a number of years. I would do that again. I think my skiing days are over because none of our grandkids will ski with me anymore because I'm too slow.
You
So,
can't go on the Black Diamond
I can't go on
Hills,
the
huh?
Black Diamonds. They try to take me on there, and that only happens once. And so we want to make sure we just continue to visit family and do that. My older brother has now been retired for about 10 years, and we always laugh about this because his response is, well, what do you do with all your time now? And first of all, number one, it's whatever I want. And number two, there just doesn't seem to be that much time. And I just have constant lists of things, but there is this idea that I'm not so time driven anymore. That's why I'm the last one to show up here this morning. I'm not so time driven. We've lived our whole lives on these time schedules, and I understand that, but it's such a relief not to have that time schedule. And so while I have these ongoing lists, 9 times out of 10, if I don't get to it today, it's still going to be there tomorrow, and I'll do it tomorrow or next week. I mean, whatever I get to it. And so my wife has really observed much, much greater relaxation. I don't think I noticed it, but being on the Supreme Court is a pretty stressful job, and I'm not asking for sympathy. I'm just saying. But I think my wife felt like it had changed me a little bit mentally, and just constantly being on such high alert that it wasn't really healthy for me. And I'm healthy, so you can edit that out too. I don't have any health issues. I'm healthy, but I'm also just calmer and just so much more relaxed now.
Well,
And I feel like I've had a career.
Yeah.
It's not that it's over, and I'm not going to not practice law if I want to, or help out at legal aid, and I'm going to do the senior judge duties and responsibilities. But as my wife and I say, and you could all probably say this as well, we've been working since we're 13 years old, and it's time to enjoy the fruits of your labor, because not everybody gets to.
Right. My dad told me that if you ever run out of friends or need more things to do, buy a pickup truck.
Oh,
And
yeah.
You'll have all kinds of friends then.
That's a good idea.
So,
That's a good
so
idea.
stay away from that. But just in closing, I mean, what do you think the biggest misperception of the Supreme Court is? Or maybe not the biggest. What is a large misperception?
I'll tell you my own misconception, and I mentioned this earlier, is as district court judges, we always pretty much laughed at the Supreme Court in the ivory tower, and they don't work that hard. And I can tell you and I'll just attribute this to the person who said it was Justice Mansfield, and his only experience is coming from the Court of Appeals, but he said he thought his time requirements on the Supreme Court were about 50% more than on the Court of Appeals. And then Justice Heck, we had this conversation in our conference room with everyone, and Justice Heck agreed to it. And I don't know, because I haven't been on the Court of Appeals. What I do know is that trial court judges are very, very busy as well, but this is busy on steroids. It's really very time consuming. And what I did last fall, it was after I had retired, but I was asked to speak to the Inn of Courts in Cedar Rapids, and it happened to be Justice Baker who invited me. And I was just going to talk about different things, and he said, well, why don't you do this? Why don't you just explain to all of them exactly what you do, And so I started out, and so I did. I just took their month of like October, and we're really, really busy in September. It's all front-loaded in September and October, just like I'm sure yours is. And so I just went through the calendar and then tried to do in my own mind an estimate of what it was going to, time-wise, what it was going to take. And so it took me like a day just to kind of pencil that out and get my thoughts together for that. And then when I went and spoke, I started out by saying, okay, how many of you here in the audience think that, you know, the people on the Supreme Court don't work that hard? And, you know, nobody, of course, raised their hand. They're chicken. They didn't raise their hand. But I said, okay, well, even if you've never said it or thought, you have thought it, haven't you? You know, and so then I proceeded, and it took me 45 minutes just to explain all that, and I didn't mean to take up all the time, but we still had, you know, time for questions. That's probably the biggest misconception, or it was my biggest awakening. You know, and I didn't take the job thinking, oh, this is going to be so much easier, but it's just a very, very difficult one. It's that change of mindset that everybody has an opinion, and if you've ever worked on a board or a commission and you try to get 7 people to agree on anything sometimes, you know, it's really, really difficult to do that. And that can be frustrating because, as I said, I always tried to have my own internal time that I was going to circulate my opinions. And so between my clerk and I, you know, we always had pre-draft opinions anyway. Then we'd conference it, and then I'd say, okay, well, now this is how we need to tweak it and do all this, and I want it done within 30 days. And I want it done, and I want it circulated because I want to get all my things done. Well, it just never works that way because, and I appreciate that. Everybody is absolutely entitled, but it's hard when you're used to being in control of things. You're no longer in control of even the timing of your opinions. And so just as an example, my last opinion that came out last June was heard, I think, in October, and I'm sure I had it done by, well, you know, totally done from my perspective by about the 1st of December, and it didn't get out till June. Well, you know, I can't tell another sitting member of the court, you know, what are you doing on this? You know, they have their own cases, they have their own things that they're working on, but it does get frustrating because it's like, well, just look at it. You know, just are you going to write? Are you going to? Well, I haven't had time. I'm going to look through the record a little bit more. You know, and then 6 months later, the opinion comes out finally.
Yeah.
And so I got a little impatient on that. But I think that's what people don't appreciate when they say, well, it takes so long to get these opinions out. This is the reason why. And with those juvenile sentencing cases that we did a number of summers ago, and we did those 2 summers in a row, we would spend literally a whole day just conferencing and arguing and trying to persuade the other, you know, that this is the right way to go, because it was a 4-3 at that point. And so when we talk about conferencing a case, and that took all summer. Those didn't come out till later on. We had our own self-imposed deadline of June 30th to get everything heard. No, people needed more time to look at it, more time to write, and I'm just not that patient sometimes. But I think that's a conception that, well, why can't you get this out? I mean, what is the problem with that? That's my explanation, and a lot of people don't care to hear that explanation, but that there's 7 of us, and we all have a right to hear it. We all have the right, frankly, to take as much time. Sometimes we try to impose deadlines on people to say, well, and I think they did this in the previous courts, the first thing you had to work on was, if you were going to dissent, the first thing you had to work on was your dissent, instead of working on your own cases so that you're not holding up my case. Right. Well, I was going to say this earlier on, but I guess I'll save it for now. Judges are an independent breed, and they don't like to be told what to do. And when you're a district court judge, as I said, you can set your own schedule and you can make your own decisions, and you get them out whenever you want to. Up here, you don't have that control like you did then. One final anecdote, when we started, several members of the court, new members of the court, not me necessarily, just said, well, we need to be putting out, I think we need to raise our cases to 150. And the other members of the court are just like, it's easy to say, because that person was a real type A and wants to get it all done and show that we're working and doing all these things. And they just said, well, you can say that, but that's not realistic to do that. And then other people have the information that other courts, they'll put out 75 or 80. The U.S. Supreme Court only puts out, 70, I think, or 60 cases a year. And many other state courts, we're more prolific than many, many other state courts, but that's not even the point. The point is, in order to fully look at these cases and analyze them and make sure everyone has the opportunity to look at it and review it and write if they want to, it just takes time. And you can only do about probably 100 to 110 cases, which I think is what the standard has been the last, I don't know what it'll be this year. That's what it's been the last number of years. And these are, as other people are prone to say as well, these are the most important cases that the state of Iowa has. That's our responsibility to do that. We're sorry it's not as quick as people would like, but we're going to do the best job that we can. We're going to do it right. And again, to the best of our ability, each one of us individually, and I have no doubt about, that they're all working hard. There's nobody that's slouching up here. There's no one who's not really giving it their all. It's just not on your schedule necessarily. But I personally don't think, and now those judges that I just talked about that wanted to push up the limit, we got to show that we're really working. After about 2 or 3 years, we all come down to the reality check that if you get 110 cases out, and they're the good quality cases that we all expect, then that's about what you're going to get. So that's probably a misconception too. Why don't you take more cases? I know some people have criticized us for transferring too many cases to the Court of Appeals because they are so busy and they just do a tremendous job, and I know that. And I think we all appreciate that as well, but we do attempt to make sure that we're just hearing the 100 cases or the 110 what we consider to be the most significant cases. And some of them, we have to do any constitutional question, and most of the statutory interpretation ones that have impact, we have to do those. The other ones are more discretionary, and I trust everybody does the best job they can in exercising their discretion and voting to either take these cases or not take them.
So when I've done interviews of potential judges or employees or things in my career, usually at the end I'll say something like, are there any questions that you wished I'd asked?
Nope, there's no questions. I thought you did a great job.
Well,
I appreciate all
that's
the...
not what I'm looking for, but but is there anything that you want to add? Because this is I don't know how long we've been at this, but this is your hour of fame or your hour and a half of fame.
I'm not sure how interesting it's been or how productive, but the only other, the final comment that I have as well, and I said this at my retirement, even back last summer, merit selection was under attack at that point. I said it at that point, and I still believe it today, that it is the best system that we have. And my fear is, and I know this is in litigation, but I'm not going to hear it, so I don't have to worry about it. But I think the way they've tried to tweak it, I'm not saying it's a perfect system, but I don't think it required the tweaks that I think the legislature ultimately passed. I don't agree with it, and I think as we talked or started our conversation maybe off the record, you know, I don't like the idea of injecting more politics into our judicial system, and I think it's just a bad thing. And I think merit selection is just what it says. It's supposed to be based upon merit, and along with all those other attributes, which I won't repeat again. Those are what makes a good judge, not somebody who necessarily thinks the way the legislature thinks or thinks the way that the executive branch thinks. I mean, we're three separate co-equal branches of government, and we're expected to function that way. This is strictly my opinion, of course. I can't speak for any court at this time, but I think when the legislative body, which is a political body, when they start wanting to make the rules about how judges are selected, and when the executive branch likewise wants to have greater control. They already have control. They get to pick the person who's going to be on these courts. I don't think that you have to make greater appointments, or have the majority of appointments that are going to think the way that you do. I just think there's something wrong with that system, and so I was really disappointed in that. I don't know where it's going to go. I think our merit selection system has worked tremendously over the last number of years, and so I don't know, we'll just see. But that was one comment I made last summer or last fall when I retired, and I think it's still an important issue today. The other one was taken care of. At least the judges got raises. That was the one thing I was always most disappointed about on my time on the court, is that we try to work with the legislative branch and with the executive branch and working on the budgets, but we were not able to produce what we really wanted, at least 3 or 4 of those 7 years that I was on the court, and I'm disappointed in that. But last year they did get a raise, and I think everyone's happy about that. And guess I'm going to go to the judges meeting. I don't know if you are.
I am,
and
yeah.
So we'll find out when we get over there in a few minutes what everyone else thinks, but they should be pretty happy with that, I think. So other than that, thank you so much for agreeing to do the interview. I appreciate it.
My pleasure. My pleasure.
We have a small tradition. We're going to stand behind you here a minute.
Okay.
So we get all 4 of us.
You want us to stand as well?
There. No, you're fine. Just
Okay.
stay seated.
All right.